Um, can I use my?
Well, we've got a timer right there, right in front of you. You see,
yes.
when the light's green, everything's good. When the light turns yellow, it means you're running out of time. You've got a couple of minutes left, close to that. When the light turns red, it means you're out of time.
Okay. Good morning, Your Honors. My name is Nene, Gloria, and Ananaba, and I am presenting the appellant's case today.
Can you pull the mic down a bit? Thank you.
This case is about contumacy. The contumacy of a gambler who has consistently defied court orders without consequence. The appellee was already in arrears in his child support payment as of the date of the parties' divorce in 1997. This is because pendant-light child support was ordered during the separation. He has continued to be in arrearage permanently. He has not been current in his child support obligation one day. He pays what he wants, when he wants, and he has gotten away with it. Appellee has always made great money, both as the former vice president for Bank of America, in his financial brokerage business, and in his gambling career. But he has consistently flouted child support orders. Many people would do the same if they had gotten away with contumacious behavior for 26 years. As of March 11, 2022, the appellee owed $171,000 in child support arrearage, although the minor children in this matter are now have aged out and are now 26 and 28 years old. The appellant filed civil and criminal contempt petitions and provided the statutory notice, but the court set the initial hearing date 7 months out. Then the matter was continued several times at the appellee's instance. Each court date, the appellant, who resides in Nashville, Tennessee, would drive 3 hours to Memphis, Tennessee, and then at the start of the court hearing, the appellee would request a continuance, and the court would grant it. The matter was finally heard by a magistrate on October 18, 2019. The court was actually inclined to grant another continuance on that day, but the appellant was insistent that the matter go forward. At the appellant's election, the magistrate conducted a criminal contempt hearing and then ruled that the appellant did not meet her burden of proof and dismissed her petition. The appellant filed for a rehearing before the judge on the same day before leaving Memphis to return to her home in Nashville, and it was again set out another 7 months to May 8, 2020. Well, by that date, COVID-19 had arrived. Now, the first continuance of the rehearing was at the instance of the appellee. His attorney at the trial court requested the hearing because the appellee wanted time to raise money and make a bulk payment, and he was requesting loan forgiveness, which there are provisions for under the statute. The appellant was agreeable and agreed to that continuance. 3 months later, on the court date, the appellee announced that he was unable to make a lump sum payment, and his attorney was not ready to go forward. And so another continuance was granted. After that, on each court date, parties would appear by Zoom. The court would ask whether the appellant wanted to proceed with the criminal or civil contempt. Appellant always elected for criminal contempt because none had been conducted in the 26 years. She had filed both civil and criminal contempt petitions over 5 times, and each time the trial court would elect to only conduct a civil contempt proceeding. It would sustain the petition mostly and order a purge payment, but sometimes it would give as much as 30 to 45 days for the appellee to make the purge payment. Now there were subsequent continuances because of the illness of both parties and illness of appellee's counsel. Each time, parties would appear by Zoom, appellant would state her preference, and the court appeared to be amenable to her consistent requests for an in-person hearing. On the final appearance date via Zoom, before the day the matter was actually heard, on March 11, 2022, the judge asked that the matter be set for 11 a.m. in the morning to allow the appellant time to drive from her home in Nashville to Memphis for the hearing. However, the court clerk sent a notice of a Zoom hearing. The notice had instructions, but it had no instructions about uploading or sharing documents. Therefore, the appellant assumed that there would be another continuance. On the court date, she requested a continuance, reminding the judge that she had consistently requested for an in-person hearing and that the court seemed amenable to it, but the judge denied the motion and insisted that the parties move forward by Zoom, essentially denying the appellant her due process rights. Appellant submits that this was an error. A court abuses its discretion when it employs reasoning that causes an injustice to the complaining party.
Did the trial court acknowledge in any way or make any statement about whether the hearing was supposed to have been an in-person hearing and how perhaps any misunderstanding may have occurred?
Yes, it did. The court acknowledged that it was supposed to be an in-person hearing and acknowledged that that was the reason for the 11 a.m. setting, but the judge said that obviously the court clerk made an error and sent a Zoom notice. However, the court was going to move forward because the matter had lingered a long time.
Did you consent to that?
The appellant not only objected, but appellant stated that she would have difficulty presenting evidence that she had, to which the court responded that the appellee had now, at that time, been paying what he was ordered to pay consistently for 3 years. And therefore, the court was not inclined to put him in jail anyway, since he was now in compliance. The court then stated that it was its discretion to elect whether to proceed on criminal or civil contempt. and decided that it was going to be a civil contempt petition. Now,
Was there any discussion about that, or did the court just say, we're moving forward?
yeah, the court just said it was going to move forward, and it also stated on the record that it was up to the court to decide whether to conduct a civil or criminal contempt hearing, and the appellant did reiterate that she wanted a criminal proceeding, but the court said it would move forward with a civil contempt hearing, and that's what it did.
So you filed two different petitions?
Correct.
Was your civil contempt petition ever disposed of?
The civil, yes, it was on that date.
How was it disposed?
Not prior to that date. It was just the criminal
Right, I
contempt.
mean, the court heard the criminal contempt, theoretically heard the criminal contempt.
Correct.
Did it ever hear the civil contempt?
No, it didn't. The magistrate didn't.
Okay.
And then appellant filed for a rehearing before the judge and wanted both petitions heard. And court seemed amenable to conducting both hearings in person, but on the court date, the court announced that it was going to conduct a civil contempt hearing. That is normal for Shelby County, Tennessee. Appellant has filed 5 to 6 petitions, criminal and civil.
So you still have a criminal contempt petition outstanding that has not been heard?
Yeah, it was discarded completely. And the initial hearing by the magistrate was a criminal contempt proceeding, at least that's what he called it.
You say it was heard by a judge.
Yes.
Was it actually heard by the judge, or was it heard by a magistrate?
It was
sitting
heard
as a
by the judge de novo, so I'm going to focus on that one. The judge announced that it would conduct a civil contempt proceeding and said that it was within the discretion of the court.
So, just so I'm following correctly, you had one hearing by a magistrate, and then you appealed that hearing
Yeah.
decision, and you requested a hearing by the judge.
Correct.
And that is the hearing that we're talking about that took place via Zoom rather than in person as you had anticipated.
That's correct. Okay.
It was heard by a substitute judge.
Yeah,
Right, it was heard by what the order says.
a special
substitute
judge, yes. Well, the basic principle of due process is that individuals be given an opportunity to have their legal claims heard at a meaningful time and in a meaningful manner. Mansell versus Bridgestone and AM Tire. The record is replete with instances of the appellant asking for an in-person hearing and telling the court that she wanted a criminal contempt petition. This was during COVID. A lot of things were done by email, so there were actually emails exchanged with the court and all parties. During the decisions regarding the grant or denial of a continuance are fact-specific and should be viewed in the context of all the circumstances existing at the time of the request. In re Bentley J, citing Osage versus Pickland Temporary Services, these circumstances enumerated in that case include the length of the time the proceeding has been pending, the reason for the continuances, the diligence of the parties seeking the continuance, and the prejudice to the requesting party. The trial court elected to proceed on the civil contempt and discard the criminal contempt completely. So it established at the beginning that there was a valid order which was not followed. State ex rel. Murphy versus Franks. The burden of proof was then on the contemnor to show inability to pay. Peary versus Peary. Appellant then testified that the appellee had paid as ordered during the 3 years the petition was pending, and that he owns a Bentley Flying Spur automobile valued at $203,000. She also testified that the appellee owns real estate in Cordova, which he had owned for 23 years, valued at about $300,000. The appellee admitted that the Bentley Flying Spur was registered to him and that he had no note on it, but he stated that it does not belong to him. He also admitted that he had paid as ordered for 3 years, but he asserted that that was because his brother was assisting him. He offered no proof.
All right,
Then,
you've used your
Sorry.
time.
then his, I have 22 minutes. Can I?
No, ma'am, you've used all your time.
It still says 25.
Well, when the red light comes on, you've
Yeah.
used your 15 minutes. We've got your brief, we've got the record, we can review it, but you've used the 15 minutes that the court allows for oral argument. So we will take this matter under advisement. We will render an opinion as quickly as we can, and you'll get a copy of it.
Thank you, and Your Honor, if I may please direct the court to carry out whatever order expeditiously, not 7 or 10 months later.
Ma'am, we move these cases very quickly.
Yeah, he shouldn't continue to be rewarded for thumbing up his nose at the rule of law.
I understand your argument. Thank you. All right, we will be in recess until the call of the docket this afternoon.
All rise.